Yeah, good morning, everyone. Welcome to the next podcast of Elite CISO. So, Elite CISO, you all are aware about it, so I don't have to introduce. So, I just want to share because there are a lot of people who are consistent with us. So, I just want to share one of the good news what we have. Our whole group has been further expanded. So, last month we have signed the MOU with Israel. So, our Middle East group and Israel, we have signed strategic MOU on knowledge sharing and also working with them on a research and innovation and working with their startups. So that is one of the good step. I feel that as a community we are really having a good position. So that's a good news, and thanks to all of you, for your active participation, and we really look forward for further active participation for all of you so that as a whole community we grow together. Right. So, so coming back to today's agenda. So today we have a very hot topic discussion on, PDP bill, privacy data bill has been already now approved in both the sessions. Now, what do we do, right? What do we have to do? How is it going to impact our life? So that's why we felt like, with multiple people who have already been experienced in other areas, like whether as a part of contribution to the act or as a part of implementation of GDPR. So that experience we thought we should bring it to our community, and therefore we have two speakers today. One is Akshay Garkel. So we are going to have a good discussion with Akshay Garkel. Just to introduce quickly Akshay. I mean, I can't introduce Akshay in quick 30 seconds, but I'll try. So Akshay, although I personally know Akshay for a long time, but Akshay has been a very senior professional and very, very proficient business leader. I have worked with him in the past. He has been the leader for 23 years, and right now he's working with Grant Thornton as the partner, and he's handling India, APAC, and Middle East region. So that is, and he's having multiple last, I think, 15, 17 years, I have been working with him on a cyber side. So he's a very, very senior professional. Therefore, we thought his experience will get for our community to share the knowledge. He has been not only handling the business, but in addition to that, he has been very active in knowledge sharing. So he has done a lot of major presentations at different levels, like with the community, with the other professional environment, and with the ministry. And the recently where G20, the international conference, was there last month, he has been the commenter in G20 and also worked in the background a lot. He also works with RBI and so many other regulatory SEBI and all. So that is what he is. And then he has also published a lot of papers in multiple media. So, so Akshay, if we can just give quick 30 seconds. I can talk about what I know, but I think I'm sure 99% there's a lot which you know and which I don't know. So if you can have your 30 seconds introduction.
Thank you. Thank you so much, Anuprita, Fal, for inviting, and EliteCISOs, of course, for inviting me over. I think, my introduction is I'm still a student in cyber and I want to always be a student. That means I want to keep learning and then obviously contribute, in our own way back to the community and society at large. Akshay Garkel, I've spent more than 2 decades in the industry. First 10 years of my career was a fair amount of technology hands-on. I kind of weathered a lot of storms with the data center and then kind of, moved to the consulting side of business. I've been working with various professional services firm for the last 10 to 15 years. Currently, I'm a partner and I lead the cyber practice for Grant Thornton Bharat. That's my introduction. Thank you. Back to you.
Yeah, thanks, Akshay. Yeah. So this privacy, which is the discussion of almost a decade, which earlier it was with Europe and now last 5 years it's happening in India. So I have one very quick question from the community perspective, right? So how it goes is like, how does the bill impact CISO and what additional checks are expected to implement?
Absolutely. That's a great question. And I think we all as CISOs have this question, in terms of understanding. I think, CISOs basically orchestrate the organization and all the technical measures and, evaluation of data security to make sure that, privacy at large is successful. and that is something that we cannot take away from the CISOs. And it's again a very important requisite even from the bill's perspective. Today, we've seen that CISOs oversee an organization into a security program. They safeguard the data, they manage the risk, and also enforce measures, like data protection, incident response, and breach notifications, and all of that. If you look at the bill, we've got the bill very clearly talking about, the fiduciaries. They're also basically talking about, the need for a data protection officer, consent manager, and obviously a data protection auditor, right? They've also mentioned that if the data fiduciary is a significant data fiduciary, then appointment of a data protection officer is mandatory.
Yeah. So this is like maybe the elevation of what data security, what we talk about it. So till now we were talking about the data protection, but now this is on whether my data is being used with my willingness, what is relevant to me, or my data is being used. So there's quite a bit, I think, from the, so one is the role of CISO where we have to start looking at the consumer perspective. Uh, so my next question is that, because from the working professional perspective, that is one side of the coin, but just going to the other side of the coin is from the citizen perspective. Okay, how this bill is important for citizens and what is it in for the Indian citizens?
Sure. So if you look at the bill from a citizen's perspective, the law basically aims to empower Indian citizens with data control, ensuring informed consent, transparency to the rights of each individual. Again, if you look at the Digital Personal Data Protection Bill, it establishes a very comprehensive legal framework, right, for managing digital personal data within the country. It also basically covers the digital data for processing, including online and offline data, once that offline data is digitized, right? So today, if I look at me as a citizen, I've got information which is my Aadhaar card information. I've got my KYC information. I've got my card financial information. I've got my generic information like my age, gender, then fair amount of sensitive information like health records, my hobbies, where all have I traveled, what social media access and what all have been my preference while accessing social media, right? All of that information is something which obviously we as citizens want to make sure that it is not misused. It is on need to know basis, and at the same time it has our consent before it is shared anyway. So I think I really welcome the bill. As a citizen, just keeping corporate and businesses aside, as a citizen, I would say it's a welcome change where, our honorable, IT minister also basically mentioned that, this particular, bill is to make sure that, there is a right to, access my information. There's a right to redressal. There is a right essentially to eraser. And of course, at the time of death of an individual, there is a right to basically transfer as well, which we call it a digital inheritance per se. Yeah.
Yeah. So just extension of the same question, right? Will this avoid the incident like Analytica?
Could you repeat that again? Sorry.
Will this avoid the incident like Analytica? It's a very, very well-known, the incident where social media data is being used, but individual data is being used.
Yeah, I mean, see, there is no one answer to it, whether it would avoid something like an Analytica. But again, if you see the statements which are coming up from the government as well, that by when is this bill going to be put to use and what are the timelines for businesses to essentially comply. I can tell you for sure that the thought process is that the first uh, uh, you know uh, uh, the people or the organizations or the businesses or the legal entities will be the tech companies and who are substantive, fiduciaries. And at the same time, they have actually named a few companies which are large companies in the data center business, cloud services, or social media companies who are handling a fair amount of data. And then it will then go to the startups and the digital native ecosystem and so on and so forth, and the mid-market companies. But having said that, the government is very clear and they are conscious about issues like these, and hence they would want, to kind of tackle these organizations at first. Again, having said that, the statements are also soft pedaling, which says that we will negotiate a timeline. We don't want to, give a deadline, but obviously it has to be a mutual consent, but at the same time keeping the whole objective of the law into consideration.
Mhm. Yeah. So thanks. I think that was a good impact understanding for CISO, like, okay, what will be the impact and what will be the benefit? Yeah. If I get into the CISO role, there are a lot of, legal terms, right? Now, PDPP bill has been passed in both the houses, but there are these three keywords which we are saying, and from the CISO perspective, like, how do we differentiate between the bill, act, law? Like, what do we take this and how will that be applicable for our job profiles?
Sure, sure. So see, after passing in both the Lok Sabha and Rajya Sabha, the bill will be sent to the president for assent to become a law. While having said that, the bill is actually nothing but a proposed law which is undergoing a legislative consideration. While an act is a fully approved and an enacted law, as we all know. So when it was tabled in Lok Sabha and Rajya Sabha, that time it was a proposed act. Now, yes, the status, and I'm sure Khushbu will be able to put more light to it, but the status, of course, is an act subject to clearance from the president. And then, of course, there is going to be a gazette as well, which is going to be created. Once that happens, then it becomes a full law. And then, of course, also wanted to mention, if you see the clause 40, right? Clause 40 essentially talks about delegated legislation. Now, the delegated legislation is something where they have given all the considerations, and the government typically, again, based on certain speeches and the forums that we keep hearing, they're saying anywhere between 6 to 10 months is when they will come up with all the compliance points. They'll come up with all the details, in terms of consent, notified consent, itemized consent, and so on and so forth. Plus, the roles and responsibilities of the data protection board, and the appointments. Earlier, the appointment was to be done by the central ministry only for the chairperson, which is as per the draft in November. Now, all the members of the data protection board essentially will be a part of being appointed by the ministry. Again, the new concept called as digital office has been introduced. So the roles and responsibilities of digital office, how they're going to operate, and how is it going to be online, what's going to be the modus, what is the application and the toolings that will be available for citizens to kind of put their grievances and things like that, are all going to be decided through this. So the government is anticipating 6 to 10 months for that.
Okay, so I have a lot of questions even on this, but just a curiosity, like when this PDPB bill drafting started, so and May 2018 or July 2018, the GDPR enforcement was effective, and since then, so an initial discussion was it's a customized version of GDPR. Now, after the final thing, like how do you compare the draft PDPP bill now with GDPR, and what do you think that what are the common controls between both, and then what are the differentiating factors with both?
Sure, I think it's a great question, and businesses essentially have already spent money in complying towards GDPR, and boards are actually asking today that is this spend going to contribute to my compliance to DPDPB as well. GDPR, so GDPR and DPB are both principle based and are predominantly at par with one another. Let me put it that way. both GDPR and data and the DPDPB have the extraterritorial effect. They emphasize on privacy principles such as storage, limitation, data minimization, extra layer for child data protection, data subject rights, and grievance redressal mechanism, and so on and so forth. Right. So that is something which is already there. Now, if I basically talk about the differences or what is uncommon between the two, I would say the DPDPB applies to the digital personal data only. Uh, you know, um, it also basically gives the right to nominate and waive off the rights from a portability standpoint. The bill also lays down some special categories, right, of data fiduciary termed as significant data fiduciary. Um, I'm just talking about some of the key salient points that we see in DPDPB, which is different to GDPR. Then, there is a concept of consent manager, which has been introduced in DPDPB. And the job of a consent manager is essentially to, report directly to the data protection board. And then, if we see DPDPB does not differentiate between personal data and sensitive personal data, which is very clearly defined in GDPR today. So these are some of the points and obviously once we have a clarity in terms of what is sensitive information, what is personal information, then probably we can draw more parallels to GDPR. And what is the government really expecting?
Yeah, and this might be a little bit clarified in next 6 to 8 months, probably.
Yes,
because once
that is what
definitions are clear.
Under the pretext of the delegated legislation, there will be clarity coming in.
Yeah.
In fact, when I read each of the clauses in the bill, against every line I have 10 questions myself. But yeah, of course.
So if I wear a CISO hat, honestly, I have many hundreds of questions to ask, but I'm just limiting it because considering I have to take out my hat of a CISO here.
Absolutely.
Yeah. But honestly, being a CISO, it becomes see, some of the organizations, they're very sure about it, like, okay, where this role will reside. But when there's no, so some matured organization has a clarity about where will this reside, but some organizations may not have the clarity. Plus, even so, any information protection or anything becomes like a default CISO job or something like that, right?
Yep.
So as per the bill, in the bill, is this really very clearly, explicitly called out that whether DPO will reside independent or DPO will reside at particular location? And on the ground, from GDPR perspective, what do you see? Like, okay, or your judgment on the ground, whether DPO will with the CISO or it will be with legal or compliance. So what is your judgment on the ground right now? What do you think what may happen?
Right. So Anu, if you look at the DPO role as such, right? The DPO basically handles the data privacy custodian of, I mean, I wouldn't say custodian, but they are they manage the governance from a data perspective, especially looking at the classification of information which is required under the purview of the law to be protected. CISO obviously manages information security, and then the legal function basically addresses all the legal aspects. I would say a DPO will be a combination of all of these, right? And obviously, it is important that the DPO function as such be an independent function. I'm not saying that CISOs cannot handle. I'm saying that the function has to be independent and it has to be conflict free. And then, of course, you basically overlook things like privacy regulations, privacy contractual clauses, managing the data subject rights, right? They can all work cohesively with each other. At the same time, not supplement one another. For significant data fiduciary, we've seen that a DPO is a must. So there, in those situations, you will need to hire. But for other situations, you can, some organizations even have DPOs which are reporting into CISOs today. Some of the DPOs are reporting into the direct compliance function specifically for REs, which are regulated entities. right? So it depends on which sector does that business fall into, what are the regulatory obligations that they're already complying towards, and then subjective calls can be taken.
So this extension to this question, can this role be looked at the elevation for the CISO also?
Absolutely. Absolutely. In fact, if you look at the situations where a DPO is directly reporting into the CXO office or the chief compliance officers, definitely it is an elevation. But again, looking at what sort of uh, uh, you know uh, information that the organization processes and the volume of information, and within that information as well, how much of PII and sensitive information does the organization. So today, even if you look at a mid-market organization, which may be a BPO in nature or a KPO in nature, they may even fall into a significant data fiduciary category because they are processing a lot of information. They may be into cold callings, they may be running a certain business process, they may be handling a process which involves a lot of customer data, or they may even be handling a lot of financial data, right? So they are sitting on a huge chunk, a volume of information, though their revenues may be a mid-market revenue, right? Uh, so there a DPO will be a must, and the DPO has to be independent. Versus you take a manufacturing organization where within the manufacturing organization, you have a situation where they are not handling too much information from a PII because they are manufacturers. Obviously, that PII and the sensitive information will be handled by their ecosystem, third-party providers, but they may not be accountable for it direct because they are not the ones who are sourcing that information, right? They may have third-party information, but that will be limited to only the ecosystem third party, whether it's an inventory management or it is a sales distribution and so on and so forth.
So just concluding of this, one more question is, will there be any industry where this will not be relevant?
I don't think so, because
I can't think of it.
if you have your employees, maybe if I'm an independent consultant providing services, maybe it's not relevant, and I formed the organization, it's not relevant to me. And that's the way I'll answer it. But obviously, if you're handling, employee records, you're handling, third-party records, you're handling, your temporary employees, which are your contractors, and so on and so forth. Yeah, I mean, it is relevant. It will definitely be relevant. But the tune to which it will be relevant will differ, and that is what we want to see. How does the government categorize those businesses from a revenue and turnover perspective?
Like housekeeping and the blue collar jobs, like that is the housekeeping, so, or the small courier businesses and all.
Companies,
So I think
absolutely.
everybody will be in that bit. And as you're saying that the depth might differ from business to business.
Government wants to support the startups. They want to support the Sunicons. They want to support the digital native explosion companies. So they are going to soft pedal it. They're going to handhold them, get them towards compliance. I don't think it's going to be a stick approach. It is what's in for you sort of an approach. And again, let me give you one example, right? Uh, it's not only a fear factor for businesses, it's also a business advantage. You take an example of Apple, right? Um, uh, when they basically went ahead and got themselves compliant from a privacy standpoint, they used that word privacy to gain end customer trust. They said that now we are the only company in the mobile solutions or handhelds where we basically protect your email IDs. We don't, you can when mask your email IDs, right? And then they played to that with a huge marketing on privacy. And they said we are the only players. Of course, the other players will follow if they want to, but we have the first mover advantage.
I think that is what you really well said, because even when I get a question from our business teams or our business members, the first anxiety what everybody has is, oh, okay, will this stop my business? And this could be a good marketing front also for the business side to say that, okay, we are safe and we are compliant to privacy so that you also get more quality kind of business, right? So I think that's a very good point what you mentioned.
I can give you another example. Look at insurance companies today. The first port of call in terms of collecting information. Now, 9 out of 10 companies have gone digital, but there are still few companies who take information on paper. Then they may destroy the paper, but this information essentially is taken through a lot of third parties who are collecting information on behalf of those large organizations. That information goes and gets digitized, and then there are protective controls to secure the digitized data, right? But what happens if that paper essentially gets leaked out? Then, so now here the business advantage is that you stop the paper base and convert your non-digital assets to 100% digital assets, which will also give you efficiency and optimization in running that process, right? So that's the business advantage.
Yeah, true. I completely agree with you. So in your previous one, you had mentioned about the difference between the GDPR and PDPP, right? So in this the draft bill, your PII, I mean, is this called out? I think you mentioned that it's not called out. So how does the law interpret personal information? Like by the time we get the clarity, how do we interpret PII? It might help the CISOs to, to find out where do I start with it.
Right. So CISOs of companies who are already focusing on GDPR, who are already focusing on a unified privacy framework, would have already got this defined in terms of what is personal information and what is sensitive information. Of course, I can tell you the DPDPB. This version basically lacks the distinction between personal data and sensitive personal data. And they're treating all the data as personal, unlike the 2019 version, which had the distinction. Again, the term, when you say personal data, it basically refers to any information about an individual that can lead to their identification, either direct or indirect through that information. So, for example, my age, my gender, my hobby, right? My health records. I think healthcare industry CISOs definitely, because at the end of the day, I can even tell you that an appeal to the government should be that from a converse perspective, how are you going to make sure that this reporting mechanism is not misused by individuals? Otherwise, businesses will only keep focusing and kind of responding to. So how do you identify those false positives? That is very important as well. And how do you basically have a balanced view of the bill rather than only protecting? I I agree that individual rights, to protect individual rights is very important, and that's the whole objective. But how do you kind of prevent misuse? This will also lead to, by the way, a lot of cyber crimes, I can tell you, because people will start misusing that and calling. So how are the CISOs, if they are responsible for this function, how are they going to basically set up some sort of a help desk for employees, help desk for that they can come and basically talk about the issues if they have seen that the organization has leaked any information, the information is floating. How does the function basically help them? So that is another school of thought that essentially should be there, is what I would suggest.
Yeah, that's where the anxiety comes to all the professions, not only to CISOs, to all the businesses also. Uh, Coming on the actual law implementation perspective, I have a lot of questions. Like every line, as you said, like okay, in every line there are 10 questions. Although it can't be addressed in one this thing, so we'll have multiple sessions on deep dive. But now, till the time we get the clarity, right? What do you think that where do the organizations start looking into the gap assessment? And in the bill, it is not explicitly mentioned, but what is the timeline what government is expecting for organizations to be ready?
Sure. So one is that before I talk about the timelines, it's important that organizations basically must offer transparent notices. They should lawfully gather the data. Now, what is lawfully is something that you know we need lawyers to interpret, and how it comes under the gamut of the word lawfully. Uh, then obviously appoint DPOs, or at least enable the DPO function at large. Uh, Enforce technical measures, because you need to kind of have specific controls. Against those controls, how are you basically monitoring the health state of that control, how it is performing and things like that, the way exactly we do for the cybersecurity maturity and things like that. And then establish a grievance redressal mechanism. I think that's going to be very, very important. That could be one way to begin with. As I said earlier, the bill does not talk about the timelines. However, there are, the Honorable Minister of State, Union government basically mentioned that, we will essentially take about 6 to 10 months to kind of list down everything that is required from a bill perspective, which is already there in, I think, clause 40 or clause 20, I think. Uh, yeah. So yeah, clause 40, my bad. It's called as delegated legislation. And uh, then they will essentially decide. Somewhere there were speculations of 18 months to comply. Somewhere there were speculations of 24 months to comply. But it is, we have to wait and watch in terms of how much time. And then different organizations may be given different times. That also we are hoping that happens, because you cannot apply the same yardstick across all businesses.
That's the better approach, actually. Yeah. Yeah. So my next question is that by November, there was one version which was there for the reference. So and now this is the final version, right? So what do you see the difference between this November draft bill and the final bill? Maybe key differences.
Yeah. So at a high level, I can tell you there are enhanced definitions now based on what came out in November 22. There is a digital office incorporation which has happened. The measures are not only legal now, but they're techno-legal in nature. Formation of a consent manager or appointment of a consent manager has been introduced, and definition is very clearly given in the law. And then the streamlining of rights. Government privileges somewhere have been reduced. Is the overall consensus when you go through this in this bill is pretty clear about it. And then of course there are few other notable changes that you can see. Of course they're still silent on personal and sensitive information, so that is something which we look forward to.
Yeah. You mentioned about government privileges are reduced, so if you can just elaborate a little bit on that.
So basically once you have a right to erase, right, you do a last mile and then give a you know notification that your data has been erased. But at the same time, you need to maintain that information for law enforcement agencies. You need to maintain a copy for the state government. You need to maintain a copy for any other organization which can have legal proceedings against that particular individual. Right. So that was kind of a government privilege per se. But again, we feel that it is important to have that as well, but that should not be misused for any other purpose.
Okay. I think good clarity on that. Yeah, because otherwise it was that privacy, but government has the whole data and government can do whatever you want and all, right? So a lot of loose talks which are happening right now.
Questions for CISOs here, Anu, would be how do I create a zoning on the architecture front? What do I do with that information? How do I mask it or encrypt it? How do I compare or make sure that there is no integrity compromise to that information? And when there is a right to erase, that means that that information has been forgotten. Then, I hope that the information does not get revealed or leaked out, because then it's a violation of the consent as well. So all of those questions today CISOs are thinking, and they're saying that, and then plus, do I have that appetite and technology to do a last mile eraser? Because I have information floating in so many areas. So hence, is data classification important? Is building a specific area and tendency of storing my PII zoning is important. And then again, I'm alluding towards a bit of zero trust here as well. So zero trust as a concept, can that help me as a control to kind of make sure that my PII and sensitive information is within the boundaries and does not percolate out without my notice or without my approvals or authorizations.
Okay. As I said, like I have too many questions, but last question for this episode. Which are the areas in the bill that still need clarity, right? Because this will help CISOs also to work out on this is the clear, right? Clear, the clauses or definitions, and these are still yet to come.
Right. So one clarity that is required is if you see the November 2022 bill, there essentially we had information that can be from a cross-border perspective can be shared outside the country to preferred geographies. Now, the word that is common is the restricted nations. So you cannot share information with a restricted nation. However, that list is yet to be given, and that list will keep evolving depending on various factors. Various reasons, geographical reasons, political reasons, diplomatic reasons, and so on and so forth. Numerous procedural details, again, are deferred to the delegated legislation. So we are going to wait 6 to 10 months is what they mentioned. And cross-border is something that I've already mentioned to you. So these are some of the areas that, still need clarity. I think I've been harping throughout the conversation that difference between personal and sensitive information is not given. So we need clarity there as well. And of course, a lot of legal points also need a lot of clarity in terms of, the list is endless. I can keep going on.
Yeah, and procedural in the sense that today the country is not restricted, but tomorrow if it happens, then how do you come back?
Exactly.
How much time will that be allowed? So I think there
How
are
do
a
you roll
lot
back
of things. Yeah, although as I said, like okay, the business point of view, there is quite a bit benefit. So from country economy, country positioning perspective, also there are a lot of benefits of starting the journey. Like privacy is the journey, and we are starting the journey based on what we think is right from the country perspective or from our this perspective. So and I'm sure that it will take few years to mature to the level, and definitely it will give us benefit on a cross-border business perspective also. So from country perspective, it is really a right step in a right direction. How much depth would we go from the day one, whether we are prepared to take a end-to-end similar to GDPR, because GDPR also has evolved almost over a period of 7 to 10 years. And obviously it will also take us some time to come to that level. But I think right step in the right direction, and knowing the kind of complexity of business and geography, I think this was much needed, and that is what government would have thought about it. So my few takeaways which I have noted from reading the bill and from this discussion is like, okay, one is that this is just a start. We can take this maybe November for definition. We can take November bill and start working out on that, and the definition as we get the clarity in the definition. All CISOs and DPOs can talk to the business and keep on, giving the clarity to the business. Also understand about, how, and from the day one, I think we should start not to make this bill as the bottleneck, but as the enabler. And as you gave, the example of Apple, how nicely this can be used as one of the marketing tool, and use this for the benefit rather than as the downside of it. So that is the positioning, which is very important, and all of us are going to be a part of that positioning, and that's very important. Third thing is that provide enough notifications to the consumer. take the explicit consent, take the data what is really needed for the business purpose, and keep the data with you till the time it is needed, and then don't keep unwanted data. So that is another thing which will really help. And then obviously technical and security measures will be around. There'll be some differences like right to audit, right to information, right to deletion. So those will be the addition to what the existing controls, what all the CISOs and the technology professionals are trying to put it. So that will be the next enhancement to that. As you mentioned, like consent officer and grievance redressal. So these are going to be two very, very critical part, right? And that is where we need to start building those awareness within the team, within the organization. That will be helpful. Address the breach notifications in a timely manner, because obviously there's going to be a timeline. And as you said, like, okay, there might be misutilization. So have your controls and processes and procedure in place so that if there is any miscommunication by the attacker saying that my data is being breached, I think that will help to safeguard the CISOs. There are some more nuances, and I think we really need more sessions for knowing the bill in depth. So this is just a start. And Akshay, thank you so much. I know that it was very short notice, but thanks for agreeing to come and join us on the webinar and share view for all our participants. Thank you so much. And we really look forward to have more insight for our community and partner with us or help us to understand the bill, so that we don't reinvent a bill every time. We just take the experiences of different people and make this as a platform to make it more understandable. So thank you so much, Akshay, for joining us and share your views on that as a contributor, as the listener, as a researcher, and the implementer in some organization for different data privacy bills. So thank you so much for joining us.
Thank you so much. Thank you. Thank you.
As this was one part of it, and as during the conversation we talk about, there are a lot of, and Akshay had mentioned about a lot of legalities will come in picture, and therefore we had got the legal person also to share their views, and Fal will have a few more such questions for the legal person, Khushbu. So Fal, over to you.
Thank you, Anuprita, and it was really insightful session. I was like, I remember now the word that the more you study, less you know. Technically, I've written about 18 questions for me, even just to understand the concept what Akshay have just mentioned, and I'm sure everyone would have the same questions. So I would request everyone just note down your questions in the chat now. What we'll do is we'll cover the legal part with Khushbu. And once we end the session, we'll take all the questions and answer both from Akshay and Khushbu's area. So let me introduce Khushbu Jain, is advocate and cyber expert, Supreme Court of India. Welcome, Khushbu. Thanks for joining and taking this particular invite. I lost you, Khushbu. Can you hear me?
Hi, thank you, thank you, thank you so much.
Great. So now what we have learned, the first part of it was around CISOs and everything. Now it's a time to discuss the legal part of it, right? And I wanted to start with very, very basic, right? Me as an Indian citizen, like not as a CISO, what are the benefits for me out of this bill? I mean, layman's will take a little while to understand it, but we want to hear from you.
All right. So if I start with for the users, like laymen like you and me who are the users, despite being CISOs or advocates, all of us are users. So there are a lot of rights which are provided in the new bill when it comes to data principle, that is you and me. And to start with, the aspect of obtaining information about what are you processing. The right that I can ask for a correction or a erasure of a personal data. Second, the third is that I can nominate somebody else to exercise right in the event of a death or an incapacity. The other one would be that there is an aspect of consent that you have to take an explicit or a clear consent from me, and there's a process of what kind of consent and how you should take it. So now I have an ownership to my data. When I say I have an ownership, till now also we had an ownership, but we practically in practice we did not had an ownership. So now you me have an ownership of a data where we can say that you can utilize my data, you cannot utilize my data, please correct my data or erase my data. Or the third one, that I do not want to, I can withdraw my consent, I do not want to be the subject of your processing of the data, I'm withdrawing my consent, provided that it is not directly linked to the kind of services that you're taking from them. And if the purpose goes away, the lawful purposes go away, you can as it is request for the data to be deleted, or to be, you can withdraw your consent. So these are few things that we have. Apart from this, you have something called as grievance redressal. So now the data fiduciary need to have grievance redressal, where we can ask that we have some issues where that can be sorted by these data fiduciaries. I mean, these are the basics in a nutshell that we have as a user, which till now we were struggling to have it in India. We did had, I mean, if you look at Journey File, uh, right to privacy came into existence with Puttaswamy judgment. But with right to privacy, you, me, all of us will agree that none of us could think of, okay, somebody has taken my data, or somebody is utilizing my data or misusing my data. Can I go and enforce my right every time, file a writ petition or a PIL in the court that my fundamental right has been infringed? So law should come with the aspect that, that it flows, there is a place where a person can go and have a proper procedure to appeal. And this law practically brings in, it's literally a balance between where me as a user know that what exactly are the data, what exactly are the things which can be taken, not taken, what are my rights under right to privacy, one. And at the same time, in the absence of, or in the event of my rights being curtailed or my rights being infringed, what are my options available? And same goes with the companies, that companies now understand what I can take, how I can take, and what I have to bring in my processes. So yeah.
Very interesting. I would say that as a CISO, we keep on giving responsibilities, defining R and R. Okay, I'll do this and I'll do that. However, as a consumer, as a citizen, now probably we also will have rights to even ask, or we have a right to even see, okay, what corporates can probably store for us. And right to be forgotten is definitely a. I'm not sure how to exercise that, but I'm sure we'll need your help, obviously, if we really want to do it. And probably government will make it simple in the time to go, right? Great. So with that, let's move to the corporate, right, where everyone is hardly is highly impacted, right? So let's talk about benefits first. Let's, as a corporate, is it really beneficial for me to have this particular bill, or do you feel that okay, there are benefits of this bill?
There's not a straight answer to it, but in a way, I would agree that it is good, because state of lawlessness is never good, especially when such kind of regulations exist in maximum of the countries if you look at worldwide. So in that scenario, no lawlessness doesn't solve our purpose, because we are talking about data, we are talking about our existence, which is borderless, and there is no jurisdiction over here. Cross-border data sharing is another aspect to it. So looking at all that, I think it was high time that a proper legislation comes in place, which brings in some stability and understanding among the corporates, that what exactly are the duties, what exactly are the exemptions, what are the liabilities, and what are the rights with the data fiduciary, which is corporates per se. So in that way, I would say it's a very welcome move for the corporates, because now that they understand that this is the law, because see, no state became an issue where can you share the data outside, can you not share it? Tomorrow, let's say all of a sudden something comes up, some regulation comes up, and you'll be like, okay, my entire systems are in place. There's something called as design that you do it. So by design, is it there or not? Will there be some laws or some judgments that will come up where I will ask to delete certain data, so right to erasure? So now is the system where they know that okay, these are the 5 principles which companies have to abide with, and bring in their system, bring in their process, so that things can go streamline and businesses can work. Also, we are looking at something called as penalties here. I mean, CISOs would understand because, for CISOs, one benefit here is they have not, with this bill, they are not asking how security has to be maintained. That's at the liberty of the CISO right now, at the corporates. So for them, as Akshay was talking about, there's no segregation of data and there is no demand that what kind of security standard you have to keep. So it is up to you which vertical and what kind of data you keep. You compartmentalize yourself, what is sensitive, critical and personal for you, and with kind of industry you are, what kind of security standards and measures you have to kept in place. So that's the liberty which has been given to you as a company, so that you do not get into a place where citizens data is been in the hands of in outside, it gets attacked or it goes out. So that's where I think it's a beautiful move, that it's talking about privacy, it's talking about rights, but at the same time it's giving freedom to you, that I'm not telling you what's sensitive, what's personal, I'm not telling you security standards how to be maintained, but you do all that because that's where people's this right will be maintained. So up to you how you have to do it.
Absolutely. I mean that those are, I would say, the golden words which we all want to hear, because everyone now is talking, okay, काम बढ़ गया, and then we'll have to do a lot of things, right? So now let's talk the other part of the bill. Uh, what do you see as a repercussion or overheads for the corporates to comply with all these rules, right? It's not easy. I mean, having said that, okay, this is really a benefit, but at the same time, we'll have to do a lot of work. There's a new designated person to be appointed, a lot of rules to be defined for data. There are a lot of things we already have now queries. Okay, what to store, what not to store. How do we handle the PII? How do we handle the other part of it, right? So from legal angle, what do you see are the repercussion or the other part of benefits for corporates?
See, thumb rule. Let's remember the 6 principles of data. This thing of data information, and just abide with those 6 principles, and with that look into the kind of penalties that they are coming in place, and we'll talk about penalties at the later stage. So I will talk about that these 6 principles are the one which you should have it in the process, in the system, in by design, and in the process in your system, and right from technology to people to whole process of yours should fit in this 6 principles. And if I talk about the first one, can be something called as about collection or usage of personal data of citizens of India. So when I say usage, it should be lawful. And I think before that also somebody was talking about lawful. When I say lawful, it should be for lawful purposes. It should not be for purposes which are being utilized. We see a lot of news in the newspapers which talk about that so and so had tons and tons of data, and we see how crimes happen with access to that data. So for what purpose are you taking it, and is it lawful, one, and is it legal? So the way you're taking it is legal. The second that comes is and with that also, when you talk about lawful, there must be protected from, there should be transparency that has to be maintained, like company has to now tell you that for what purpose I'm taking it. The second that principle that comes about is about data collection. When I say data collection, that means that it is for the legal purpose and it should be safely stored till the purpose is served. Till purpose is served, and after that you may have an option to delete, or you can delete the data, or you've been asked to delete the data, and if somebody like you and me give them permission, they can still continue. But with the system that you'll have to delete it. The next one that talks about is data minimization, that says that there should be a relevancy, that what you should collect while serving the defined purpose, and what is your aim for it. So I mean, I always say, not that you cannot collect more data as to what kind of services you provide, but for that you make the user very clear about it. Okay, these are the reasons we're doing it. And for companies now, companies also need to understand that if their services are this or their product is this, and for that they need the data, let go with the relevant data only. Do not take unnecessary data which is which are being kept, because you have additional aspect. One is keeping the data, the second is security of the safety of the data. The other principle is with regard to accountability, and that now comes in with the bill. Though we do have SDPI rules in place and other things, but with this brings in a more of an accountability. The next one is about accuracy. Accuracy is a job of a company. When you say accuracy, that the data is accurate and correct, and in the event it is not, if somebody seeks, you have to maintain that aspect of bringing in accuracy in the data. The last which talks about is reporting of a data breach. In case data breaches happen, reporting has to be fair, transparent, in equitable manner to the data protection board in India, and also if you're existing in any other jurisdiction. So I think these are the basic. If you bring in place as a company, you're pretty much sorted in India or anywhere else. Also looking in the kind of security standards you have to maintain. Now coming to your direct question, that what exactly are we looking out? You're looking out for, yes, a dedicated CISO, which people already have it. The bill talks about in case of significant data fiduciary, you need to have DPO in place, who will be the point of contact and who will be representing the board and who should be Indian citizen or who should be residing in India. These are the basic requirements of that. But apart from this, practically companies are looking in, yes, for hefty penalties, but with that hefty penalties, if this six principles one can implement, and for implementation you can have CISO, you can have dedicated person who understands the compliance aspect of it, the interpretation of the law and the compliance, and what kind of notices should be given out. The way you used to have fire drill in the company, in premises, physical premises, you need to understand that now you need to get into the aspect when security, the way you VIP PT you have been doing it, and analysis. Same time, you have to understand with regard to this compliance, you keep doing that check and balances, because me, all of us understand best of the security measures. If people do not understand, that also becomes a problem. So, have that at least an understanding that you understand what exactly law is and how you implement it. In case of breach, what happens, who will be the first one to answer, who will be the second person, what kind of information would go out. Because the bill also talks about that existence of any other rules and regulations continue. That means the certain notifications, the certain guidelines with regard to, notifications with regard to reporting, RBI guidelines in regard to, fintech and banks, IRDI guidelines with respect to insurance will still continue. So in all those aspects, you need to, remember that have these also in place, and somebody who understands these things, so that you understand which area you fit in and where all places you have to report your, breaches and in what manner.
Very elaborative answer, I must say. And you started with all the legal jargons. Technically, I took a little while to understand that, but I was very happy while you started using VAPT, because those are like music to my ears. Those words we use every day. But that was really elaborative answer. And I'm sure that while we start our journey, we will go through all these processes. We are just listening to you right now, but when we actually start the work, we'll realize, okay, these are the things you have already spoken, that okay, this will come someday on our way. Just to reiterate, everyone, please post your questions and we'll be handling the question very soon. There was a reminder for 5 minutes. Don't worry, we'll continue the session till 12:30. Right? With Khushbu, with that, we go to the next killer one. Let's say the bill talks about the penalty, and it's huge. Like the number is 250 crores, which is mentioned. Now imagine there's an organization whose annual turnover is like 50 crores. Now imagine there is a penalty, the organization may go bankrupt, right? How do we interpret this particular penalty? It's a huge.
Okay, so I think the whole idea of keeping hefty penalties that only that you might go out of business. So please take security very seriously and take CISOs on board.
I want
so
you
but
to repeat this. I will keep on repeating this particular sentence forever. Yeah, go ahead.
but nonetheless, coming to the aspects, see, penalty will be imposed keeping determining certain aspects. And when I say certain aspects, the board will keep in mind the nature and the gravity of the breach, and also the duration of the breach, while determining, imposing penalty on you. They will look into the aspect of repetitive nature of breach. It's an highest penalty you're talking about. It's up to 250 crores. So not that you're exactly looking at 250 crores, but at the same time, you should not forget it can be 250 and it's per breach. So you might get out of business. So keep that in mind. But while determining the areas which they will keep in mind would be the nature, the gravity, and the duration of the breach, the type and the nature of personal data affected by that breach, and then whether this is a repetitive nature of breach, that it continues, that shows your approach towards security. then whether the person as a result of breach has realized any gain or avoided any kind of loss. So that's, that shows your intention again over there. Whether they took any action to mitigate that risk or the effects or consequences of the breach, timeliness, effectiveness of such actions. So these things will determine whether there is any monetary penalty to be imposed in proportionate or, with regard to looking into the imposition of monetary penalty on the person which has impacted. So they will look into all this, and then is where they will come, and that mitigation, they might give you a stay order in the initial, or some restrictions can be imposed at the initial, but while determining the entire thing where you will have right to, appear and put your foot over there, is where they will look into the whole aspect of how your conduct has been and everything, while determining whether it can go up to 250, or it can, you're looking into something in lakhs, or something in small number of crores. So that's where it is. And there also they have segregated. And one beautiful aspect which you will see over here, which none of us should forget, that in case of a frivolous complaint coming by a data principal like you and me, in that scenario, there is a penalty imposed on that person. So I have a 10,000 of a penalty on me. That's a beautiful thing which you will see in the bill, which people are, maybe looking or failing to put focus on. So that's another. It may extend to 10,000 rupees. If you don't abide with those data. So Section 15 of the Act talks about the duties of the principal users, and in case you don't abide with it, in that scenario, you are looking into a penalty of 10,000. So that's another good thing. So I think with the penalty aspect, it's pretty good. One observation which I have it is, there would be a lot of companies whose turnover is much higher. So 250 crores would be something that they will keep it as an amount as of their expenditure, and continue for a default. So we have seen the GDPR is in existence, and there have been companies, I mean the tech giants, which talk about the kind of penalties imposed by ICOs, across in UK or in European nations like Germany or France. So we should see that as an example, and maybe some option of maybe a turnover of 4%, global turnover, 4% penalty breach should have been an option over there, or whichever is higher or minimum kind of a thing should have been imposed, because you're covering here the minimum, the MSMEs and the new startups and the small companies, but you're ignoring the aspect that 250 might be very less for tech giants, and that's where the whole data keeps on revolving and happening, and we are in their hands. So yeah,
Great.
but I mean, at the start.
Yeah, I'm sure. And there will be use cases, right? There will be first. I mean, I remember when GDPR came and there was a first penalty, it was a news all over the world, right? There was a first penalty. I mean, that's how probably people will learn. Some people are also asking about cyber insurance and everything, which will be covering. But I'm sure those areas will also be evolved, right? Right now, probably people take for having it to transfer the risk. However, now this area will be in demand further. Now let me ask you a question, right? Where we are expecting motivation from you, right? The bill has come, right? I mean, it will be passed and it will soon be act. How industry should accept this as a bill, right? Sometimes the bills or all the legality thing, technically it goes for interpretation. People find ways, if we do this, this is not needed. But should we really think that, okay, this is an overhead? Or probably we feel that, okay, let's do it with spirit. I mean, that's the best thing to do. What's your thoughts around that?
See, as at least I started with the same thing, that bill practically is very simple. If you look into the bill, unlike any other act which you will pick it up, practically it's impossible for a person without a law degree to understand those kind of things. But if you look in, this is one of the most simple act or a bill which you will look in place. Very simple, very transparent on the aspect of what are the things, and what are the liabilities and what are the duties of both fiduciary and principals, and what are the implications in case of breach, and in case of breach, where are the places where you can go for your appeal. This is the basic. And in case you go for an appeal, what kind of penalties you're looking out for. So this is something which is very basic. Implementation part, I think I would more of a say that it comes more on the security aspect of it and standards which you'll apply in your industry. And you should, because if you look into the penalty, if you're open to paying that heftier penalty or getting into that reputation loss apart from penalty, absolutely fine. You can continue of going the way you want to, or there would be some ifs and buts or some navigations that would come. But I would say this is a very basic things. If you talk about people's human rights, their data has been taken away. 90% of the crimes happen because data is in the wrong hands, and more the data easy for them to commit the crime. So as a data fiduciary, practically it becomes a duty per se without law also for you to safeguard, because you're earning out of that data, your business is dependent on that. Why not take a security measures and keep citizens or the users of your user in place? So one is the penalty, the second is reputation as well. And now is the state where you can't hide. You can't think there is an attack and data has been breached, let's just keep quiet. With the dark net, with the aspect that criminals also became smart, that encryption and all doesn't work now anymore. I'll just threaten, I'll just release your sensitive data out. 1 and 10 jurisdictions if you're into, this is more of a threat than anything else. So that aspect of key ransomware, and I'll encrypt your data, and that's where you ask money and all those things. That's a first step. The second step, criminals are smart. So if you're thinking of not looking into reputation loss, not thinking of having penalties imposed in India and other jurisdictions where you're existing, best is to have security standards in place to avoid the penalties which are there in this bill.
Great. I'm sure we'll get support with the bill. I'm sure all the approvals will be taken on the fly. We'll put a lot of tools, and this will really help, right? Now, let's also talk about from the legality aspect. The bill mentioned about consent, right? And then that's where the customer's data will be taken while you are consenting, saying that okay, I'm allowed, or you're okay to take the data or this information. Now, see, consent also have very blur area in terms, okay, you're taking this for, let's say, something, and then right now there are business models for cross-selling. Now, if you take the consent only for, let's say, buying an insurance, and let's say organization who does, let's say, cross-selling, how that will be impacted? There will be business models which will be, I don't know, which will stop, or the consent will be further elaborated. What's your thoughts around that?
All right, so that's a beautiful question. One, the data, when you take somebody's, the consent has to be must be given before seeking any data. A notice must be given seeking the consent of the person, of the user. The second, the notice should have details with regard to what personal data is collected and for what purpose are you processing that data. And it can be withdrawn at any time. Now, when I say these three things, you also have to look into the aspect that sharing with third party, sharing with your vendors, selling the data to the third party. You might be just collecting the data, but you might utilize your businesses dependent on data. So when you do all those things, this becomes very clear that you have to share that where all places my data has been shared, who are the people in the loophole, so that I'm aware that my data has been shared with A, B, C, D, and it has been utilized for X, Y, Z. Now, when I've given you permission, I might give you permission for specific, and there are other things which I'm not giving you explicit consent. I'm saying I'm denying that I do not want any services. Like there are examples where been clearly been given in the act as well. That let's say, with regard to pharmacy, that I go to a pharmacy store and I give my detailed contact details to you. That is for the purpose of you providing that thing, for me to book that medicine and for you to deliver it. Let's say I do not say that don't provide me any other. Advertisements and services. So you're sending me, it's absolutely fine. But I say I do not want for this purposes, or I ask you to delete because the medicine has already been delivered to me. Now I say delete. The purpose is done away with. You're bound to delete my data. Now, if I've given you permission for ABC, you have to tell me that thing very clearly in a very clean language. There are languages also given that you have to provide me with 22 languages which have been provided in the thing, so that I understand. The whole idea is that it's not a whole one page where we don't understand, and it's bigger, longer than the act which you see, the bill which you see right now, and we have to just put a consent to it. No. And the second, something which is not directly linked to the services, you cannot deny those services to me. Like for example, I keep giving this example, like for Uber, if I'm asking the Uber to come over here, it will ask location. And if I deny the location, practically it's impossible for him to provide me services. But at the same time, if he wants access to my gallery, if he wants access to my, to my browser history and other things with cookies, and I deny that, doesn't stop him to, provide me the services. And if I don't deny it, I'm okay with it, then they can continue using it, provided they give me the details that it will be utilized for these many purposes with these many companies. With this, there is one more thing which they have to keep in mind, which will bring in more work to the CISOs and the legal fraternity and the companies as a liability, would be, now you have to keep in mind, because you're saying that you will share with, let's say, 20 third parties of yours, and those third parties start sharing with somebody else, so they might have vendors who will be looking into. Breach can happen at any point. This is, now you have to amend all your contracts in place. You will have to bring in, when it comes to indemnifying yourself, you have to ask or make sure some cyber insurance comes in place. Cyber insurance also cannot be just a plain simple cyber insurance, something which covers third party breaches, something which covers quantifies the kind of penalties which you're imposing right now in this jurisdiction, or you look into 20 jurisdictions and then quantify and see what kind of coverage you're getting and what all things do they cover in the coverage. So all these things have to be looked into. So I think this is what will be the additional thing which companies have to look into with this aspect. So consent is, I think, very crucial, crisp, clear, concise, and as informative it can be.
It looks like I'm taking more notes and I'm adding actions into my bucket list, saying that I have to do all these things now. But I'm glad that we are highlighting this point for everyone's benefit. Someday, probably today, tomorrow, or after a week's time, we'll have to implement this. There's no option now. You don't have choice to.
Sooner you start doing it, better for you, because this will come up. Though the aspect of applicability is also pending in the bill, and if you have to look into the applicability part, I mean, it can come into force by notification in the official gazette. But at the same time, they also may talk about. They can have different dates appointed for different kind of provisions in the act to be applicable from which date, and when it will start. So that's where I think also they are being very lenient, that corporate should have proper time in implementing, and there are certain things which can be, so they can give you notifications for certain provisions to be implemented, maybe let's say 3 months, certain in a year, certain in 5 months. I mean, I'm just giving a hypothetical number, not that I have an information on that. So, but then you can look into the different sections or provisions to be implemented in a different time. So best is you start right now, bring in your systems in place and things in place, so that you don't look into something all of a sudden to, comply with.
Great. So that was my next question, but just you have already answered. So
Sorry.
to summarize, no, that's fine. So to summarize, the applicability and implementation is something which is still silent. We don't know. I think if you the earlier 2018 version had 18 months of time for implementation. GDPR also had 24 months, but right now there's no timeline mentioned, right?
They'll come up in the official gazette with the timeline, but there can be an aspect where they don't directly come up with, the whole bill will be applicable from 18 months or 1 year or 8 months. They might come up that these provisions of the bill might be applicable from, so and so date, and these from so and so date, and maybe whole act comes in existence maybe after a year or 8 months or 2 years. Looking into the severity and how important, how difficult it would be to implement industry perspective. So I think that's another good thing which they're looking into, to see the side of industry as well.
Great. I think the more I hear, probably I'll have more queries, and so as others. So let's now jump into the question and answer part of it. We are now. Can we have Akshay and ma'am as well part of the discussion? Can we see you if you are around? Yeah. Okay. Great.
Yes.
Great. So, ma'am, if you can just handle, I request you to take the questions, please.
Yeah. So I have got quite a bit of questions, so which I compile by combining wherever possible. So my first question, not my question, for participant Rakhi and Kandan. So every organization collects the employee data and the customer data. So the question is that, as per bill, is there a different expectation on the protection requirement for the employee data and for the customer data, or it's the same? So Akshay, Khushbu, whoever wants to address.
Yeah, Khushbu, you can start. I can follow.
Sorry, I didn't listen to the question. I thought she's asking you. I'm so sorry. Can you repeat the question? Apologies, Anuprita.
Yeah. So organization is collecting both employee and customer data. So as per the bill perspective, uh, is there a different expectation in the bill as per the bill for protection of employee data or a customer data?
No, they're talking about data as being data. There has been no segregation of the data over there, and practically any data that even an employee can sue you that my personal information has been kept with you. He becomes your user, so you become a data fiduciary. So definition of data fiduciary comes is the one who stores, the one who transmits, the one who processes the data. So practically, you're storing, and data is data. We are not even going into the demarcation of PI or sensitive data or critical data. So that's where I think whole thing is open, and employee data will also be included as an interpretation as a data, and there is no difference in that.
Yeah. So if I can just add to what Khushbu mentioned, just taking it one step ahead, when you look at uh, customer information, of course, you are basically sharing a lot of, you are getting a consent from the customer. Uh, Likewise, you're taking a consent from your employees as well and stakeholders too. But I think what is really required is to look at the contracts and revisit the contracts, especially when talk about employment or third-party contractors. Uh, you know, uh, Making sure that if your information is being processed by the third-party contractors and the information is not fully in your control, then the accountability also has to be extended. Uh, so from that perspective, how do you kind of de-risk yourself, at least from the penalties and fines? Uh, you talk about a reputation loss or a reputation damage that obviously can't be replaced, and then have very strong control. So we see that in the financial services industry, there's a IT outsourcing circular which has been issued by RBI. Can we also have the privacy-based controls in that particular outsourcing program, and then monitor it accordingly, and then have overlaps, right? To treat the overlaps once and then apply it to many functions.
Yeah, I think quite elaborative, right? Not only from organization perspective, but wherever the data is traveling, I think that shield has to be around everywhere, and you need to have sufficient agreement clauses. So there will always be also be impact on the clauses, what you're, you're working with the partners wherever you're sharing the data. So I think good. Thanks a lot, Akshay, for adding this also. Thanks, Khushbu, for giving the clarity. The second question is now, as the bill has been already approved and now it will become act of the after approval from the president. So the question is that now this is the final act at the country level. So will there be something additional or customized, those kind of guideline or the policies will also be pushed by the regulator, or will this be at a whole country level? This will be the single act which will be applicable to all the organizations. I know it's not.
You want to take, or I can?
Anyone, because regulator is definitely not in control.
So I think during my discussion, I spoke about delegated legislation. So controls on that essentially will be finalized. All the areas that are essentially given, as I mentioned, how is the board going to be working? What is going to be the representation? How do you basically finalize, the aspects of the redressal? How do you basically, how will the consent manager work with the board? What's going to be the protocol? All of those questions, have to be answered. And that is what they are saying, that anywhere between 6 to 10. Apart from that, I don't think there is going to be any addendum per se. But you never know, in case if there are any triggers at the policy level, at the government perspective, or there are any cross-border changes, that will happen. One thing I think which is going to be a regular affair where the list will keep changing is the list of restricted countries, right? So that is something which will be, and I know you rightly pointed out last time that what happens if I already have data exchange with a country and all of a sudden it gets into a restricted list. Then what is the rollback time and so on and so forth. So yes, answers to those questions are pending. We need to get answers there for sure.
I'll just add to it. I'll just add to it. So, so the bill itself talks about there would be notifications that would be coming in and modifications or rules that would be coming in. And for that, they will continue to do so. And in the event of any kind of rules coming in under section 16 or 42 of the same bill which we're talking about, they'll be laid in the parliament, and the same process will go ahead, while parliament is in the session, 30 days, it will continue, and they'll ask, and it will be implemented that whether some amendment or things have to be done in. So that's something which we are looking into. But I think the other part of the question was the aspect whether any other laws will be applicable in this area. I would say that the bill also talks about when you talk about jurisdictional aspect, when you talk about cross-border data sharing and localization aspect or some other aspect, there are some laws or rules which have been already existing, and the bill clearly says that any other law which is existing in that specific area will continue to be in force. So that's where I think we should look into industry specific. There would be rules which will be coming in industry specific, like SEBI, RBI, IRDI, or any other authority that might come up that will continue to do so along with this.
But with my experience, see, because this is the law of country level, right? For example, IT Act or certain guidelines, there might be a reinforcement, but there won't be any customization, because obviously no regulator would go against the country level law or act, right? So
no law
I don't see.
Yeah, absolutely agree with you on that.
Yeah, but then be reinforcement. So I think this is where with my experience, I think this is what will go. Yeah, so maybe I'll take one quick question. Answer is generally not known to anyone, but still the question is, Sachin has asked question, when DPDPD will be enforced as it's already approved in upper houses. I feel that only President Office knows about it, but both of you, if anyone of you knows about this.
It will be approved, but what provisions and since when it will be applicable is all dependent, and they have really clearly stated in the bill itself. And if you want, I'll read it again, because I think the last question with Fal, I was talking about the same thing. But just for the clarity part of it, I will read that it shall come into force on such date as central government may, by notification in the official gazette, appoint, and dates may be different to be appointed for different provisions of this act, and any reference in such provision to the commencement of this act shall be constituted a reference to coming into force of that provision. So we are waiting in part and parcel and everything, and assent of the president will be done as soon as possible. It's just a formality sake of it. So that you should not be waiting, but applicability is where you should be looking out for. Okay.
I think good clarity. Yeah. So I had taken it. Okay, when will this be applicable? So good clarity. Thanks, Virgo. Yeah. Next question, Dinesh wants to know that, okay, one is that for the new customers, maybe you might start taking the consent from the day one, but will this be, I mean, does organization also need to take a consent of the existing customers?
Should I answer, or I think Akshay will answer?
Yeah, go ahead, please.
Okay, so existing customers, not for the consent for which they have already given in the past, but from now on, since the day the bill will start be implemented or be applicable, from that day you will have to take a fresh consent from everybody, provide them details as per the guidelines provided over there as to what will be the form of the consent and format of the consent. So you will have to take a fresh consent from your existing and the new customers, because that will be in the purview of the guidelines provided in the new bill. And there would be different layers of processing and sharing and information. So I think they can even go on saying that we want to withdraw the consent, which today they can't. So for your existing, yes, the day it starts implementing, you will have to ask again.
Okay. So moving to our next question, considering the time, like we only have 5 minutes. So Parag has a question that, for building competency towards implementation of this, which existing certifications would be recommended? So I think there are some certifications like DCPLA and all. So I think there are 2 levels of certifications, right? So do you want to call out which are the certification? Which I know that DACI does one, and there is a international privacy certification.
For becoming a DPO?
Yeah.
For becoming a
One
DPO,
becoming a DPO, even within the company also, like what kind of certifications you need?
I think within the company you'll be the better one to talk about. But with regard to DPO, see the guidelines which are being very clearly been given. The requirement which is given, certifications are not a compulsion thing. It's an additional thing which you can continue to do so. But there are no certifications as a mandate to become a DPO. The only mandate you have to become a data protection officer is to be Indian, to be residing in India. One. The second one is that you will be the representation of the board, and the third would be you will be the one who will be liable from the board side, and yeah, I mean that's about it. There are no much details about how to become a data protection officer, but that's about it. You can have as many certifications from as many places, but that's not a mandate.
Okay. Okay. So last three questions. What is the impact on the need of on fingerprinting? Because in infra business, generally you have fingerprints, but you take it out, right? And prints are going out of the border. I didn't understand when you say where the fingerprints are going out of the border, but then in a total, what I understand is that your fingerprinting protection, is that included as a part of this bill?
No, that's why I was talking about, and Akshay was also speaking. Akshay can also add to it that they have not segregated with the data as to what's sensitive, what critical, what's not. Data is a data. Everything is a data, and it's in one category. And that's
additional
where
clarity may help.
Additional clarity may help or may not also help out, because that's where the thing will come when quantifying the kind of penalty that should be imposed on you is on the severity and impact of the kind of data that has been breached. So that's where I think the whole
And if I've understood the question correctly, so if you look at, say, assuming you're a regulated entity and maybe you're a a payment aggregator or you're basically a card data network, for example, and you have the payment information right from the point of sales terminal to hitting servers which are sitting globally. You have the payment string will carry a lot of sensitive information, right? Now, RBI already has mandated from a localization perspective that any instance which is not on soil has to come back to soil within 24 hours. So they call it as a T minus 24. And all foreign instances have to be deleted. So those are the additional controls which, for such entities can be helpful from a fingerprinting perspective, that, everything has to be on soil. PDPDP is silent on data localization, except for the fact that they're saying that you can take the information out and reside that personal information or sensitive information in I won't say preferred geographies, but they're not talking about whether you can take it out, but they're saying that you can't take it to restricted nations. So yeah, I mean, we'll have to see. A lot of laws are conflicting with each other. So idea is to get answers there, and what would supersede what will be another question.
Yeah. So Akshay, last question for you, because 12:30, we have only 3 minutes and 3 questions left. So the last question for you is, DPO is a business role which reports to board under GDPR and liaison with government authorities. In most cases, we see CISO reporting to CFO, CRO. Do we see the change in the reporting structure?
Yeah. So as I mentioned, if you are a significant fiduciary, you will have a DPO. If not, then the DPO function at large will exist, and it would reside either with the compliance team or with the CISO team. One thing that we really need to understand is that data protection from a privacy standpoint is not a information security problem alone. It is an organization-wide. I don't, maybe the word problem is not right here. It is basically an organization-wide challenge to pick up and then comply to. Point here is that it has to be an agenda with the board. It has to essentially have a line function in itself, and then it also needs to cut across. So if you look at DPO will cut across an internal audit function, If you look at, the data governance piece will cut across the compliance, even for that matter, the finance function. And then, of course, HR, right? Because at the end of the day, you're holding a lot of employee information there. And then you should have information security, IT as well, right? From a technical control in terms of how you're able to manage. So it cuts basically across and has an independent view in terms of how each of those functions basically are managing the data and the data flow.
I think, yeah, that's really very, very important. And also, not necessarily where exactly it will reside, but what responsibility what we take. And during our discussion, we said it might be a very natural elevation even for the CISOs also. And as the role demands, obviously organization will also look at it where the reporting should be. Yeah. Thank you so much, Akshay. The second question from Rajesh for Khushbu. What would be the reason for excluding state infrastructure from ambit of the bill or act when more personal data is going to be available with them?
Okay, see, there are a lot of reasons which have been given as an exemption. The reasons are very clear when it comes to national security, uh, when it comes to implementation of law and order situation, um, when it is required um, for purposes for lawful purposes, for implementation of certain policies, certain subsidies, and bringing in. So for any country to run, you have to understand that the state has to have data in place, and to provide and to understand and how to run, and for that they need it. So that's where the whole exemption is talking about, that for certain purposes where there are certain exemptions which have been given to to state. I mean, I don't want to go on saying that there should
Yeah,
be any
I can understand.
given,
Something
but
can be called out,
yes,
something can't be called
yeah,
out. But
yeah,
this is for the protection of a citizen, and there'll be some regulatory objectives they may have. So I think it's difficult to talk about it. But I just thought, like, okay, at least giving them a perspective that when the regulators and legal authorities are thinking about it, there's also a next level of the citizen safety, which is being looked at it, and there are few things which are needed, which may not have visibility 100%, but this is needed. Yeah.
yeah.
Thank you so much.
Like a lot of. Go ahead.
Yeah, go on, go on.
A lot of people ask about that. Can I take data from? Can now with the privacy, law enforcement or government can take data from Telegram, which is my personal data. Can they invade into my privacy? So yes, when it comes to implementation of law, when it comes to there is detection, there has to be detection or investigation that has to be done, or prosecution that has to be done, or prevention of a crime that has to be done. They have to get into that aspect, of getting into it. So.
Okay, completely agree. Yeah. Thank you so much, Khushbu. There is one more question on elaborate on chapter 4, transfer of personal data outside. But I feel that, it's going to be a very, very long topic, and which would really need the special session for that, and that we can continue in the next session. So thank you so much, Khushbu, Akshay. Thank you so much for joining us. And thank you all the participants who has actively participated and asked quite a good questions. So my suggestion, this whole recording and everything, will be keeping it we'll post it on YouTube, and we'll also have a post on LinkedIn. You might have, as you start going through it, each line, as we all are saying, that each line is going to have multiple questions. My suggestion is that in a LinkedIn post, you keep on posting these questions, because as a community, definitely somewhere who is already aware about it, those questions somebody can respond. And I'll request Akshay and Khushbu also to be active and respond as much as possible. And these questions will help us also to understand what kind of topics which we need, to be taken up in the next session, as well as make a good white paper and circulate it to everybody so that it can be useful for everyone. So thank you so much, Akshay. Thank you so much, Khushbu. And thank you to all the participants and Fal for moderating this. And I personally got a lot of clarity, and I'm sure many people would have got the clarity. And the more you get the clarity, the more questions what you get, and obviously we are going to trouble Khushbu and Akshay for that. So thank you so much for joining with us.
Thank you.
And
Thank
we
you
are
so
3
much.
minutes late, and next time we'll optimize our answers as well as our questions, and we'll try to be on time. Thank you so much, everyone, and enjoy the privacy period right now. Yeah.
Thank you so much. Take care.
Thank you. Bye-bye.
Thank you. Bye.